A Mexican is executed in the United States despite a ruling from the World Court for a stay of execution. Is the U.S. establishing justice or undermining international law? This is Inside Story. Hello and welcome to Inside Story. I'm Sami Zaidan. The state of Texas has executed Mexican-born José Medellín late Tuesday after the U.S. Supreme Court rejected his request for a reprieve in a split vote. His life was taken for the 1993 rape and slayings of two teenage Houston girls. Well, the execution took place despite pleas from the UN Secretary General and a World Court ruling saying Medellín had not been told of his rights. Frank Contreras reports.
The scene of an unspeakable crime. A Texas judge convicted José Medellín of participating in the gang rape and murder of two teenage girls from Houston. The crime occurred 15 years ago. At The Hague, the International Court of Justice recently determined that José Medellín and some 50 other Mexican nationals on death row in the U.S. were never granted their legal rights to legal counsel from Mexican officials. That right is granted under the 1963 Vienna Convention. The World Court then decided that Medellín and other foreign convicts in the U.S. should be given a new hearing to determine whether their rights were violated. But Texas still went ahead with Tuesday's execution.
If we don't respect the international instance, we don't respect the international legislation, then how can you ask other countries to do so, you know?
It's a question the UN Secretary General Ban Ki-moon is also raising. He's called on the U.S. to respect the ruling from the World Court. But Texas officials say they're complying with the U.S. Supreme Court ruling made earlier this year, which stated that an international court decision is not binding in the United States. José Medellín's legal team worked up to the last minute in a desperate attempt to prevent him from receiving the lethal injection, to no avail. On Thursday, a man from Honduras is scheduled to face execution. Attorneys argue that his Vienna Convention rights were also violated. Frank Contreras, Al Jazeera, Mexico City.
Well, joining us now to discuss the issue, our guests in Houston, Texas, Dudley Sharp, death penalty expert and victims' rights advocate. In Amsterdam, Andrew Cayley, former senior trial attorney at the International Criminal Court and currently defending the former Liberian president, Charles Taylor. And in Doha, Najib al-Nuaimi, Qatar's former justice minister and lawyer of the former Iraqi president, Saddam Hussein. Thank you all for joining us. Andrew, if I could start with you. Do U.S. states have the right to opt out of international agreements that the federal government has signed up to?
No, they don't. The United States signed the UN Charter in 1946. Under the UN Charter, it has an obligation to comply with the decisions and judgments of the International Court of Justice here in The Hague. It does not have the right simply to pick and choose which judgments it is going to enforce. And indeed, if you read the judgment of Justice Breyer, the March 2008 US Supreme Court decision, he makes this very point in disagreeing with his colleagues on the Supreme Court that the decisions of the ICJ in The Hague are binding on the federal government in the United States and on the states, on the constituent states of the United States.
So how could the rest of the judges get it so wrong in the US Supreme Court then?
It's a very difficult question to answer. I think it has a lot to do with the current politics that we are living through at the moment. There is no justification for what the US Supreme Court did. One of the problems that now exists is that other countries may well take the view that when US citizens are arrested overseas, for example, if a US citizen is now arrested in Mexico, that he or she does not have an enforceable legal right to consular representation. So the point I think that was made at the beginning of the program is this: international law rests on reciprocity between states, that they will all respect international obligations. If a state like the United States chooses not to respect its international obligations, it really begs the question why other states should comply with their international obligations.
All right, well, we'll get into the whole issue of reciprocity in a moment. I want to go over to Dudley and say, how do you feel about that, the suggestion that the US is sitting in violation of its international agreements?
Well, I think first we need to look at what the Vienna Convention really says, which hasn't been discussed yet. The violation of the United States was not that we said, no, you can't have representation from your consulate. That's not what the Vienna Convention says. What it says is that the taking authority, Texas in this case, is supposed to tell Medellín, if we know he's a foreign national, which we contend that we never did, and tell him, you have the right to contact your consulate if you want to. That's all the Vienna Convention says. Everyone admits that Texas did not tell Medellín, if you want to contact your consulate, you can.
That's a rather
Medellín
important
or
right,
his
though,
attorney
isn't it?
on his own. Let me finish. Of course it's important, and everyone should honor the treaty, but everyone makes mistakes. The taking authority, the people that arrested Medellín in Texas, number one, never knew he was a foreign national. He had spent the overwhelming majority of his life in Texas, number one. But number two, I think it's important to note that Medellín and his attorney were never restricted from talking to the Mexican consulate. Anytime they wanted to, they could have. It was never prevented. So the only violation was, we didn't tell Medellín, we didn't know he was a Mexican national, but we didn't tell him, if you want to contact your consulate, you can. The gentleman is wrong. I mean, it is, states' rights are extremely important in the United States, and the laws protecting states' rights are very, very strong. And what the U.S. Supreme Court stated was that the president, nor is there any other power currently in the United States, that makes Texas obligated to honor the Vienna Convention. That's just the way the law is within the United States, and the majority of the court disagreed with Judge Breyer. Regarding having an additional hearing, your audience also should know that Medellín did have a hearing on this exact point, and the courts found that he suffered no harm from not being told that you can contact your consulate.
Right.
So what the ICJ wanted was an additional hearing, but we had already had a hearing on the exact topic that the ICJ said that we violated, and they know we have done that.
Right, Najib al-Nuaimi, is it perhaps a technical point that wouldn't have made any difference to the trial or to the outcome, to the sentence against Medellín, the whole point of initially telling him he has the right to contact his consulate? Is it a big deal being made out of nothing?
Well, first we have to understand that capital punishment is a crime in itself if it is not based on a fair trial or a denial of a defendant to have as one step, to make sure that everything has been secure, that he said what he wanted to say.
But I think the point that Dudley was making there is that he had a fair trial. He had even access, albeit perhaps indirectly, to consular advice.
As I understand, he had no access from the beginning. The trial had been so long, and the ICJ actually based their judgment on the timing and after they have reviewed really what has been said during the trial. The ICJ, it might be, as the gentleman said, it's been already fulfilled during one hearing, but a second hearing doesn't harm if you could stop somebody to be not to be executed for even 24 hours. So therefore, we have to take care that the defendant have to have every legal step he can manage, either through the consulate or through a lawyers or through a private procedures, if we can say that, until he has to be fulfilled. Because satisfaction cannot be that easy to have a fair trial. We have been through this where unfair and justice have been carried out and people being executed in different places around the world.
Right.
U.S. have to be really in a high quality of legal procedures so far, with a very long historical judicial system, and presidents should take care really of that point which was made by the ICJ. ICJ is really mostly deliver in 2 cases so far, and not the practice of the International Court of Justice to deal on a personal basis such a crime like that. But however, ICJ is going further in their hearing to a different area and scope of legal debate, same as the United Security Council, for example, is making a lot of issues regarding Al-Hariri, for example, assassination and others. So it has been very much extended.
Jump in there. Sorry to interrupt you, Najib, but if I could go back to Andrew on a point of international law, if other countries follow suit, as you were suggesting, they might do, where would that leave the principle of international law of abiding by agreements that have been signed? I'm sure you heard there a moment ago, Andrew was quite adamant, Dudley was quite adamant that US states do have the right to sort of review their own rules that they abide by locally, state-wise.
That is actually not correct, and I would very strongly disagree with Mr. Sharp on that point. The US Constitution in Article 6 says that international treaties entered into by the federal government are described as the supreme law of the land, and that judges in all states are obliged to follow that law. Now, I believe, and Mr. Sharp can correct me here, that Texas joined the Union in 1846. At the time that it signed the US Constitution, it agreed to be bound by all of the international treaty obligations that the United States has entered into. So it is absolute nonsense to suggest that the state law in the United States of an individual state overrides international treaty obligations of the United States. Secondly, another point I'd like to come back on the issue
Andrew.
of consular representation, very briefly. At the time of these offences, and nobody in any way questions that they were extremely serious offences for which he was charged and convicted, I think he was 18 years old. The whole purpose of consular representation is in order to ensure that a foreign national overseas gets decent advice on legal representation. That is one of the primary purposes. Judge Breyer, in his dissenting opinion, explained that, in fact, Medellin's lawyer had been suspended from the practice of law for 2 periods of 6 months during and before his representation of Medellin. Had Medellin had advice from consular representation at the time, he may well have got better representation in court. And that is an extremely important right. That is a fundamental right in all countries, that an individual be adequately represented before the courts.
Well, there's plenty more to talk about, but it is now time for a short break. When we come back, we ask, do foreigners get rough justice in the United States? Stay with us.